this meeting of the Tendring District Council Standards Committee. I am Councillor Anne Wiggins and I'm the committee's chairman. I will leave introductions of others at this point, as there will be an opportunity for introductions at item 8 of the agenda for today. Public element of this meeting is being live streamed and the public may attend in person in this room too. Due to the nature of the business and the length of time of this meeting, there are likely to be breaks in the proceedings while the committee adjourns to deliberate matters or otherwise for conform reasons. I will now start with item 1 on that agenda, which is apologies for absence. Mr. Ford.
Thank you, Madam Chairman. I can report apologies for absence this morning from Councillor Jo Henderson. She's not been substituted today. And also apologies from Councillor Anne Oxley. Councillor Oxley has been substituted today by Councillor Baker. And I can also report apologies for absence this morning from Clarissa Gosling, who is one of the Council's 4 independent persons. Thank you, Madam Chair.
Thank you, Mr. Ford. Now the minutes of the meeting, which I think you've all got in front of you, from Wednesday the 24th of April. If I can have a proposer and a second for these, please, if you agree. First is Councillor Newton and seconded by Councillor Talbot. Thank you. Are we all agreed? Thank you. Right. Declarations of interest. Are there any? Is there anyone who wishes to declare an interest? Yes, Councillor Alexander.
Good morning, Chairman. I would like to declare an interest in as much as I'm acquainted with all of Councillor Turner's team.
Thank you, Councillor Alexander. Yes, Councillor Baker.
Thank you, Chairman, and good morning. Just like to say, for the matter of record, that I'm one of Councillor Turner's team. I know as a previous employee of the council and had dealings with them then. And also, just so that everybody's aware, I had a conversation with Councillor Turner some time ago in regard to the hearing, but it was a general conversation, most of which, in fact, all of which I cannot recall. But it did not refer, or no discussions were undertaken about the content, and I'm not predetermined on this matter. Thank you.
Thank you, Councillor Baker. And I would like to say I think that most councillors on the committee are have known Mr. Taylor in various capacities during their time. Oh, okay. Sure. Lisa. Sorry.
Good morning, Chairman, members of the committee. Could I, on the basis of the declarations of interest that have been given, could I just request that those that have declared interest can confirm that the acquaintances does not impact on the ability to hear the matter today? Thank you.
Councillors, would you like to
to expand on
yes.
My declaration of interest? I am acquainted with each and every member. One, via his working time within the council, and 3 remaining on Councillor Turner's team as a political allies of a political party that I personally belong to.
Thank you, Councillor Alexander.
Chairman, obviously we're well aware of, everybody's well aware of our relationship with Councillor Turner, I think, but with Mr. Taylor, that was a working relationship from 2021 until he retired, which was 18 months ago, I believe. So it doesn't impact on my sitting on this committee. Thank you.
Thank you.
Just echoing, I think Councillor Alexander, could you think that the question was, are you still in a position to hear this complaint in your mind, and that it doesn't impact on your consideration of the complaint in an open mind?
Chair, in an air of freedom and correctness, had I been predetermined or am predetermined in any way, that declaration would have been made to you. I am not predetermined, and everything will be based upon its merits and the facts as laid out.
Thank you very much.
Thank you, Chair. Just by way of my political allegiance, really, I'm familiar with Councillor Turner and the officer that's been mentioned, Mr. Taylor, but I'm not predetermined in any way.
Thank you, Councillor Land. If that's the end of declarations, we'll move on to item 4. Okay. Item 4, questions on notice pursuant to Council Procedure Rule 38. Mr. Ford?
None received, Madam Chairman.
Thank you, Mr. Ford. Right, item number 5, report of the monitoring officer, A1 report, outcome of members' code of conduct investigation. Mrs. Hastings.
Thank you, Chairman, members of the committee, and Councillor Turner and his representatives, independent persons and members of the public watching the committee today. The purpose of my report is to set out the background information and advice with regards to the Code of Conduct legislation and procedures. We do not, in this report, discuss the substantive complaint or any evidence in support of it. This is purely to provide the committee with enough information to be prepared for the hearing and to make a resolution with regards to exclusion of the public and press. So if I set out the background initially, in accordance with paragraph 7 of the District Council's complaints procedure, myself as monitoring officer is required to refer a matter to the Standards Committee where an investigation has been undertaken and concluded that there is evidence of a failure to comply with the members' code of conduct. And I have determined that informal resolution is not appropriate in this case. A complaint was received in August 2023 from Councillor Ernest Gibson, who we refer to as the complainant. He's an elected member of South Tyneside Council, and he's the chairman of the Local Government Association Coastal Special Interest Group regarding alleged behaviour of District Councillor Nick Turner under the District Council's Members' Code of Conduct. The Council's Code of Conduct is attached to your report as Appendix A, and is on page 37 of your agenda pack. The Local Government Association has special interest groups, and those special interest groups in this case was the Coastal Special Interest Group, of which the Councillor Turner was present at 2 virtual meetings on the 5th of June and the 29th of June 2023. It was alleged in the complaint that Councillor Turner had convened the District Council's Members' Code of Conduct. Any complaints that are received in relation to Members' Code of Conduct must be dealt with in accordance with the formally adopted complaints procedure of this District Council. Those complaints procedures were adopted by this council in November 2013, and they are included within your pack as Appendix B, commencing on page 53. After seeking the views of Councillor Turner on the 25th of August 2023, I decided that it was reasonable and appropriate that the complaint merited further investigation. The parties were informed of this decision and that an external investigator would be appointed. Section 5 of the Council's complaints procedure sets out how an investigation is conducted, and that when an investigation report is received, it must contain a conclusion as to whether there is evidence to support a finding of failure to comply with the Code of Conduct. I decided, due to capacity and complexity of the matter due to the resources available, to outsource the investigation, which I am able to do under the procedures, and I appointed Mr. Kenyon as the external investigator. Mr. Kenyon is sitting to my right, and you will hear from him later in the proceedings. In conclusion of the investigation, there was based on a balance of probabilities that there was sufficient evidence to show that Councillor Turner has breached paragraphs 1.1, 1.2, 2.3 and 5.1 of the Council's Code of Conduct. All parties, so the complainant and Councillor Turner, were given the opportunity to comment on the draft investigation report and findings therein, and thereafter the report was finalised on the 10th of January this year. As previously stated, if there is evidence of a failure to comply with the Code of Conduct, the Council's complaints procedure at section 7.1 provides myself with the authority to obtain an informal resolution in consultation with an independent person, where it can be reasonably resolved without the need for a hearing by the Standards Committee. Although the procedures does not require me to consult an independent person at this stage, I did so, and I consulted with Mrs. Jane Watts, who's sitting to the left of me, who agreed with my decision that the matter should be referred for a hearing before the Standards Committee so that the matter can be determined by members. The Council has adopted complaints procedures and hearing procedures, and those hearing procedures are set out in Appendix C to your report, and they begin on page 67. If the committee does determine that a member has failed to comply with the Code of Conduct, they have the power to take action in relation to the individual's behaviours that are relevant and proportionate and necessary to promote and maintain the high standards of conduct. These actions are available to the committee, are set out in paragraph 8.1 of the complaints procedure. On page 19 of your report, I highlight to you some case law which made it very clear that allegations of a failure to follow the authority's Code of Conduct can only be considered in accordance with the Council's standards arrangements. Those documents I have just referred you to are the Council's standards arrangements for this purpose. Councillor Turner has offered an apology. He offered an apology at the outset when the complaint was received, and also through the investigation process. However, on page 19, it sets out that although Councillor Turner did offer an apology, having read the investigator's report for any offence caused by his actions, which was described as unintended and unconscious on his part. However, my view was that there was no acceptance of the breach of the Code of Conduct, the evidence presented of the breaches thereof, and the evidence, and having seen the final report, and the apology was not offered by Councillor Turner to the District Council with whom he was representing at those meetings. Therefore, I did determine that it was appropriate to refer to the committee. Within your report, on page 20, you have details of the members' Code of Conduct. The Council must have a Code of Conduct by virtue of the Localism Act 2011, and in November 22, the Council adopted the revised version of the local government's Model Code of Conduct to come into effect after the elections in May 2023. The code The legislation states that you have to have arrangements in place to deal with complaints, and that is set out for you. I have also provided within the report details of the relevant paragraphs that's alleged to have been breached. On the bottom of page 21, you are given some information regarding the Code of Conduct when it applies. And for this purpose, I actually asked the investigation to consider if Councillor Turner was acting in an official capacity. Finally, with regards to the last document that you have in your pack at this stage, you have been provided with the Local Government Association's supporting guidance, which was issued in relation to their model code of conduct. That guidance is attached as Appendix D at page 71 of your agenda. You are within your report provided with details of the Localism Act 2011, the Local Government Act 1999, which sets out the council's best value duty, and one of the themes of best value is described as culture of the local authority is determined by its shared values, ethics, beliefs, and how decisions are made, as well as how elected members and officers behave, interact, and carry out their roles. You're provided with some information of the Human Rights Act, in particular Article 10 of the European Convention on Human Rights and the right to freedom of expression. You're also provided with information regarding the requirement to publish decisions and appointments to outside bodies. I've provided you with information on the Council's constitution, terms of reference of the committee. I've also provided you with details that there is a requirement that all members of the council, if you are sitting on a standards committee, that you have undertaken specific mandatory training on hearings. I can confirm that all members sitting here today have received that training. More information will be provided in the Part B update sheet. I can also confirm as well that all members sitting here today have received the mandatory Code of Conduct training, as well as Councillor Turner, which he attended on the 21st of June last year. The report sets out the usual finance and resource implications and other risks and mitigation. As I have said, it's very important that the Council follows its adopted procedures, and that whilst there is no prescription in legislation which says a matter has to go for a hearing or how that hearing may be conducted, whatever approach is adopted must follow the rules of natural justice in line with the principle of proportionality. The approach may depend upon the seriousness of the issue. So therefore, reinforcing again that you must follow the Council's adopted procedures. The committee should work at all times in a fair, independent and politically impartial way. This helps to ensure that members of the public and councillors have confidence in its procedures and findings, and decisions should be seen as open, unprejudiced and unbiased. All concerned should treat the hearing process with respect and with regard to the potential seriousness of the outcome for the subject member, the local authority and the public. Within your report, you are provided with a summary of the complaint. Councillor Turner's response to that complaint is provided to you on page 26. I've also set out the details of my decision notice that was made on the 25th of August 2023. I'd like to just draw your attention to the middle of page 27, where I said that there was a potential for a huge detrimental impact on the working relationship between the council and external stakeholders, not only within the meetings but far wider. The Local Government Association, agencies, organisations and local authorities across the country within the SIG, which is the Special Interest Group, are national bodies, and the actions of Councillor Turner are likely to be found in breach of the Code of Conduct. The alleged behaviour directed towards individuals needs to be investigated, as does whether Councillor Turner has brought the council into disrepute on such a national platform. As I have said, at the outset, the investigator's report must come to a conclusion as to whether, on a balance of probabilities, those paragraphs of the code have been breached with the evidence available. I think it is worthwhile highlighting at this stage there has been no determination that Councillor Turner has breached the Code of Conduct through the investigation report. The powers that are given to myself are to essentially commission an investigation to provide you with members of the committee the outcome of that investigation. We are saying to you, both the investigator and myself, that we feel there is evidence which is sufficient enough to show that there has been a breach of the code. But that determination, is ultimately yours as the decision makers today. Within the report, you have been provided with extract from the hearing procedures, which are, extract of the complaints procedure, which relates to the hearing procedures. They are set out in paragraph 7 of the complaints procedure and are repeated on pages 28 and 29. And again, you are given a summary on pages from 29 through to 32. You are given information regarding the hearing process. The council's complaints procedure states that the investigation report will be retained in Part B until the day of the hearing. You, as the committee, therefore, as all hearings this committee is acting like any other committee of the council, and you are required to consider whether to exclude the public and press to retain the report and the hearing within Part B, which will be in private. I have provided you with my advice on page 30 of the agenda, and I will read this out to you. That acting in accordance with 7.12 of the Council's complaints procedure, the investigator's report will only be kept confidential and remain in Part B until the day of the hearing to protect the parties. The committee is required to decide whether to pass a resolution under section 100A(4) of the Local Government Act 1972 for the press and public to be excluded from the remainder of the meeting on the grounds that the conduct of the hearing will involve the likely disclosure of exempt information as defined in paragraphs 1 and 5 of Part 1 of Schedule 12A as amended of the Act. In making this decision, the committee will give consideration to whether in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Article 6 of the Human Rights Act 1998 establishes a presumption that the meeting will be held in public unless a private hearing is necessary for one of the reasons specified in the article. This is set out in Part 5 of the Council's Constitution, Access to Information Procedure Rules, Part 5.4 to 5.6. I recommend in the report that the exclusion of the press and public resolution is not passed to enable the hearing to proceed with the investigator's report in public. I just wanted to add a couple of extra paragraphs in relation to this advice, which is set out in the update sheet which has been circulated this morning. Confirmation that the advice is set out on page 30 of the agenda pack applies to additional information and the updates which have been circulated to the Standards Committee members and the subject member, Councillor Turner, on blue pages currently held in Part B. While an investigation under the Localism Act 2011 is not covered by the right to a fair hearing under Article 6 of the European Convention on Human Rights, as the outcome of any hearing will not impact upon the rights of a councillor to carry out their role as a councillor. Any investigation must nevertheless abide by the principles of natural justice. A hearing is like any other committee of the council. The rules around access to information also apply, as they do to other committees, in that the hearing will be in public unless there are lawful reasons for it, all or part of it to be heard as exempt or confidential matters. I have again included the quote from the Guidance on the Members' Code of Conduct Complaints Handling published by the LGA, which states under its hearing section that the panel, which is referring to you as the committee, should work at all times in a demonstrable, fair, independent, politically impartial way. This helps to ensure that members of the public and councillors have confidence in its procedures and findings. Decisions should be seen as being open, unprejudiced and unbiased. My advice, therefore, would remain that the resolution is not passed. However, we did request Councillor Turner, and he was asked whether he wished to request any part of the hearing to be held in private, and he's indicated to myself that he would like the investigation report withheld. He's confirmed that he would like the investigator's report to be retained within Part B, and therefore I believe Councillor Turner should be asked to make representations or through his representatives on this point to the committee before you make your decision on this point, as that would only be fair and reasonable to do so. Members of the committee, I present the report to you and the recommendation on pages 18 to 19, and are happy to answer any questions that members of the committee may have.
Thank you very much, Mrs. Hastings. If we now go to, I invite anyone who would like to make any comments, and if we go committee first, independent persons, and then Councillor Turner or one of his representatives who would like to ask a question, then please do. So any members of the committee would like to ask any questions, and remember that this is only to do with what Mrs. Hastings has just said, not anything to do with the Part B. Councillors? Nothing. Okay. Independent persons. Nothing. Councillor Turner.
Apologies, Madam Chairman. On behalf of Councillor Turner, he's asked for the Part B inclusion for the second half of this, on the grounds really that he's already suffered quite considerably as a result of these allegations being made and the subsequent investigation. He's lost his attendance at committee, he's had his party whip withdrawn from him, and he's already had his role as a councillor severely reduced on the back of these allegations. I think he would just prefer that to trust this committee and its open and independent hearing to make a decision before we release any press release or any statements made to the public. He thinks that's fair, we think that's fair, and that's the way we'd like to proceed.
Thank you very much, Mr. Taylor. Yes, please.
Paragraph, the two paragraphs that are quoted are paragraph 1 of Schedule 12A, and the other is paragraph 5. One is in relation to personal information, and the second one is in relation to. Is there anything by way of representations that Councillor Turner, through you, Ian, say about particular possible clauses that would enable the committee to make a decision to exempt. At the moment, it's exempt by virtue of those. The committee has now got to consider that and weigh the public interest in disclosure against protection of the industry or legal advice.
Yes, could you repeat the second part of that, please, Keith?
Paragraph 1 is legal advice. I was just struggling to find a copy of Section 12A. And things that we can, and probably put that in front of you and give you a few seconds to just read it. And it's 1 and 5. Just take them. We give you a few moments just to read that and then think whether there's any specific representations you want to make on those 2 points.
Sorry, Madam Chairman. I've had a quick look at this. Obviously, it's quite difficult to sort of fathom the detail or reasoning behind it, but the information that we'd like withheld from the public at the moment is the allegation that Councillor Turner is a racist, which comes out in many of the statements involved in this. And we think that that's a matter that should stay private until it's been proven to be true.
Thank you, Mr. Taylor. Any questions from the committee? Independent persons? No. No. We will now adjourn and we will be back in some time, and either Mr. Simmons or Mrs. Hayes will let you know when we're coming back in. Okay, I shall read the recommendations on pages 18 and 19, and then I will give the decision after that. Okay, and after I've read the recommendations on pages 18 and 19, I will ask for a proposer and a seconder to those recommendations from the councillors. Okay, the recommendation as set out on pages 18 and 19 say that the Standards Committee, A, notes the contents of the report in readiness for deciding whether to exclude the press and public before a hearing is undertaken, and B, notes the monitoring officer's advice in respect to the exclusion of the press and public as contained within the report. Right. May we have a proposer and a seconder, please?
I'm quite happy to propose as the recommendations read out.
Thank you very much, Councillor Baker, and thank you, Councillor Alexander, for seconding that. And now I will read the decision. Oh, sorry, are you all agreed? Okay, thank you very much. Okay. Decision on whether to exclude the public for the discussion of the investigator's report and hearing of the complaint. The committee have considered the resolution set out in the agenda at item 6, namely that under section 100A(4) of the Local Government Act 1972, the press and public be excluded from the remainder of the meeting on the grounds that the conduct of the hearing will involve the likely disclosure of exempt information as defined in paragraphs 1 and 5 of Part 1 of Schedule 12A as amended of the Act. Whether to exempt material and consideration of a matter under the exempt provisions referred to is a discretion for local authorities. It is not a requirement. In considering the resolution in the agenda, the committee has been made aware that paragraph 1 of Schedule A concerns 1. Information relating to any individual. Here, exempt information is in this category if and so long as all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. By way of examples, names, addresses, or telephone numbers can identify individuals. When considering information relating to any individual, the committee will also consider the Council's Data Protection Act responsibilities. And paragraph 5 of the same schedule concerns information in respect of which a legal or a claim to legal privilege, professional privilege, could be maintained in legal proceedings. Here, exempt information falls in this category if and so long as in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Privilege lies with the client, which broadly is the council. The monitoring officer's advice, as set out in the A1 report, acting in accordance with paragraph 7.1.2 of the Council's complaints procedure, the investigator's report will only be kept confidential and remain in Part B until the day of the hearing to protect the parties. The committee is required to decide whether to pass a resolution under section 100A(4) of the Local Government Act 1972 for the press and public to be excluded from the remainder of the meeting on the grounds that the conduct of the hearing will involve the likely disclosure of exempt information as defined in paragraph 1 and 5 of Part A of Schedule 12A as amended of the Act. In making the decision, the committee will give consideration to whether in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Article 6 of the Human Rights Act 1998 establishes a presumption that the meeting will be held in public unless a private hearing is necessary for one of the reasons specified in that article, as set out in Part 5 of the Council's Constitution Access to Information Procedure Rules Part 5.4 to 5.6. Consequently, it is recommended that the exclusion of the press and public resolution is not passed to enable the hearing to proceed with the investigator's report in public. From the update sheet, confirmation that the advice as set out on page 30 of the agenda pack applies to the additional information and updates which have been circulated to Standards Committee members and the subject member, Councillor Turner, on blue pages and currently held in Part B. While an investigation under the Localism Act 2011 is not covered by the right to a fair hearing under Article 6 of the European Convention on Human Rights, as the outcome of any hearing will not impact upon the rights of a councillor to carry on the role as a councillor, any investigation must nevertheless abide by the principles of natural justice. A hearing is like any other committee of the council. The rules around access to information also apply as they do to other committees, in that the hearing will be in public unless there are lawful reasons for all or part of it to be heard as exempt or confidential matters. Decisions should be seen as open, unprejudiced and unbiased. Councillor Turner was asked whether he wished to request any part of the hearing to be held in private and wants any part of the investigation report to be held. He confirmed he wished the investigator's report to be retained in Part B, and therefore the committee received representations on behalf of the subject member, Councillor Turner. Having considered all relevant matters, the committee concluded that the public interest in disclosure of the information around the individuals referenced in the report at item 7 on the agenda, and the information in respect of which are claimed to legal professional privilege in the same report outweighed the public interest in withholding that disclosure. As such, the committee does not approve the resolution at agenda item 6. As a consequence of this, the report at item 7 shall be placed in the public domain to facilitate the physical placing of the report in the public gallery and the access to the same through the council's website. The committee shall adjourn for up to 15 minutes and then continue with consideration of that report and questioning referenced in the remaining items on the agenda associated with this hearing. Can I please have a proposer and a seconder for what I have just read, please? Okay, if we have Councillor Baker to propose and Councillor Newton to second. Thank you. You all agreed? Agreed. Thank you very much. That dispenses with item 6, and now we're going to adjourn for 15 minutes or so that the report can be made public, and either Mr. Simmons or Mrs. Hayes will let you know when we're coming back in. Thank you. Right. Can I just, Mr. Ford, make sure that find out from you whether the papers are now in the public domain, please.
Thank you, Madam. Yes, all the previously Part B private confidential documents are now on the website and are viewable by the public. And I can also confirm that a copy of the Part B material has been handed to Councillor Harris, who is sat in the public gallery watching the proceedings. Thank you, Madam Chair.
Thank you, Mr. Ford. Right, we now come on to item number 7, and I believe that is Mrs. Hastings.
Thank you, Chairman, members of the committee. The Part B report for you, which is now into Part A, agenda item number 7. The purpose of this report is, again, as a recap, that in accordance with paragraph 7 of the District Council's complaints procedure, the monitoring officer is required to refer a matter for a hearing before the Standards Committee where an investigation concludes that there is evidence of a failure to comply with the member's code of conduct and the monitoring officer has determined informal resolution is not appropriate. The Part A report that you considered earlier this morning provided background information, advice with regards to the code of conduct, legislation and the council's procedures. This Part B, this report appends the investigation report and provides additional information and guidance for the committee to consider through the hearing process. The investigation report is attached as Appendix E and I believe commences on page 27 of this part of your agenda pack. You were notified earlier that I had appointed an external investigator, Mr. Melvin Kenyon, and his investigation report is attached as previously referenced. He has provided, as required by our complaints procedure, a conclusion that based on a balance of probabilities and the evidence available, paragraphs 1.1, 1.2, 2.3 and 5.1 of the Council's Code of Conduct have been breached and provide additional information on capacity as requested through the investigation process. I made reference earlier to the hearing procedures which must be followed and the decision that the committee is required to undertake today. This report also highlights to you that an investigation report is to be treated as an explanation of the essential elements of the case and a justification for why the investigation has concluded that there has been a breach of the code or not. The report should cover agreed facts and disputed facts and whether those facts amount to a breach of the code or not and reasons for reaching that conclusion. In many cases, the committee may not need to consider any evidence other than the investigation report and any other supporting documents. However, the committee may need to hear from witnesses if more evidence is required or if people do not agree with certain findings of fact in the report. The Standards Committee must determine whether, having considered the report and the evidence presented, Councillor Turner was acting in capacity despite not being formally appointed to local government association, coastal special interest group as an outside body on behalf of Tendring District Council. And should the Standards Committee, following consultation with the independent person, determine on a balance of probabilities that Councillor Turner has failed to comply with the Members' Code of Conduct, you have the power to take action as may be relevant, proportionate and necessary to promote and maintain the high standards of conduct. As highlighted earlier, those actions available to you are set out in paragraph 8.1 and were included in the earlier report. I just want to provide the committee with an update and for the public record as well. And this update sheet has been provided to Councillor Turner and his representatives. So in addition to the report and investigation report, some additional information has been provided. That is to include the recorded text of Councillor Turner's interview with the investigator. That's been provided. Councillor Turner's defence submission has been provided to you. Councillor Turner requested a number of questions to be asked of one of the witnesses, Becky MacDonald-Lofts, and she has agreed and provided written responses to all of those questions posed by Councillor Turner, including the original one which the Standards Committee had decided to rule out. So she's answered all of Councillor Turner's questions, and you have that before you, and that's been provided to the other Councillor Turner's representatives as well. I also wanted to point out a clarification question which was received by one of the members of the Standards Committee when they were reading the pack. It's in relation to, I'll read it verbatim. I just wanted to point out that on page 26 of the public agenda, under the heading Councillor's Response, fourth line down reads, he obviously didn't understand the modern mind, yet in part B, page 39, 5.2, subject member response, 8th line down, it reads, I truly do understand the modern mind. Which of these statements are correct? Is this an oversight? My response to that point of clarification was as follows. Thank you for your email and being so thorough with your reading. You are correct in the extract from Councillor Turner's response on the 18th of August 2023, page 39 on blue pages, states, I truly do understand the modern mind. My summary in the Part A report comes from the words he used in the interview with the investigator, which was as follows. As I said in my email, I'm shocked at how what I said can be so misconstrued, and I truly do not understand the modern mind. I stand by what I wrote in that email. I have read it back several times to myself. It was an instant response, and I thought that was what was required. I don't comprehend this. I find it appalling. It shuts down conversation. I've therefore carry on. The email from Councillor Turner on the 18th of August did miss out the word not, but he used not in his interview, which is confirmed in the statement which I have circulated to all of the committee. Thank you for highlighting this, and we will make reference to this in the update sheet, which is what I've done. Within the previously Part B report that you have, you were notified on page 10 that we had asked Councillor Turner a number of questions when we sent him the hearing procedures, which are suggested as best practice to do. We asked him whether he wished to be represented at the hearing, and if so, by whom. He said he had 3 representatives. These representatives are here today. We asked whether he disagreed with any of the findings of fact in the investigation report, including reasons for any of those disagreements. Councillor Turner's response was that we consider there are few, if any, findings of fact within the report. The concerns revolve around omissions in the report and where the witnesses have made statements without any backing evidence. My comment there is that no matters of dispute were provided at the draft report stage. Whether he wished to give any evidence to the hearing, either verbally or in writing, Councillor Turner responded, yes, I've attached my written defence submission for circulation to the committee in good time for the meeting. I can confirm that defence submission was circulated to all members of the committee on Friday, the 10th of May. He was asked whether he wished to call relevant witnesses to give evidence to the Standards Committee. Councillor Turner's response was, we have requested that witnesses attend so that we can establish the robustness of their evidence, but they have all declined, including, it would appear, the complainant, who as yet has not responded, making the procedure inherently unfair to myself under natural justice. I've attached a list of questions for Ms MacDonald-Lofts to answer in writing as offered. As I've already indicated in this update sheet, those questions and responses have been circulated to the parties. We asked whether we wish the hearing to be held in private, and you've previously been made aware of that, and you've now made your decision on those points. A member of the Standards Committee actually requested that members be provided with both parts of Article 10 because it was only referenced. So therefore, within your update sheet, members and the parties have been provided with both parts of Article 10 as requested. I've also included in the update sheet that the three-stage process, which is set out on page 10 of the Part B report, used by Justice Wilkie in Sanders and Justice Beatson in Calver, was also referenced in another decision, Robertson on versus Buckinghamshire Council. The judgment, when considering domestic authorities on the application of Article 10 to decisions of standard bodies under the previous statutory scheme, it is stated that the principal basis of that challenge was that the decision was in breach of Section 6 of the Human Rights Act 1998, as it violated Councillor Robinson's right to freedom of expression under Article 10 of the European Convention on Human Rights. In the High Court, Mrs. Justice Lang concluded that the claim should succeed. She set out at paragraph 74, the Deputy Monitoring Officer, who in that case was actually the decision maker, failed to refer to the statements made by the complainant, and given the importance that was placed upon those statements for the purposes of the Code and Article 10, it was considered a significant failing in the assessment and the decision-making process. It was not possible to say what a difference it would have been made to the outcome if this exercise had been properly undertaken. She also said at paragraph 94, in conclusion, I found the Deputy Monitoring Officer's interpretation and or application of Article 10 flawed, in that she failed to give effect to the complainant's enhanced right of political expression. In making the decision under Article 10.2, I conclude that the interference did not fulfil a pressing social need, and nor was it proportionate to the aim of protecting the reputation of the other councillors. As an elected councillor taking part in a public meeting called by the parish council to discuss the Green Belt, the complainant was entitled to enhanced protection offered to the expression of political opinions on the matters of public interest, and the benefits of freedom of expression in a political context outweighed the need for the protection of the reputation of other councillors against public criticism, notwithstanding that the criticism was found to be a misrepresentation, untruthful and offensive. It is my summary to you as Council's monitoring officer is therefore, when reaching your decision as Standards Committee, you must record your findings with your decision and undertake the required assessments by following the three-stage process as set out by Justice Wilkie, and in that case where it was concluded that following applying Article 10.2 to the facts of the case, the appellant's words were no more than expressions of personal anger and abuse and did not constitute political expression, which attracted a higher level of protection under Article 10. So my advice to you as the committee is to make sure that you undertake the test and come to your assessment recording your findings. And finally, in relation to the update sheet, one of the members of the Standards Committee pointed out to myself that the date in the first recommendation A on page 7 said the 5th and the 29th of June 2024. That should have been 5th of June and 29th of June 2023. So as the report also provides you with information on the Human Rights Act and 1998, gives you the full details of the test to be applied on pages 10 and 11 when you're making, and 12 when you're making the decision. The report also provides you with guidance from the Local Government Association's Model Councillor Code of Conduct, dated the 18th of July, which makes reference to freedom of expression. The report gives you a background of the allegations. However, I'm not going to go into those because you have the investigators' report to consider today. The thing I would highlight, however, is that a number of witnesses have been interviewed. They are listed on page 14 of your report, and you'll hear more about those shortly. There were allegations in relation to breach of the Code of Conduct in respect of respect, discrimination, disrepute. Within your report, there are evaluations of both of the meetings for you to give due consideration to. They are extracts from the investigator's report. So again, I'm not going to go into details at this moment. Once you are now at a position where you, in accordance with the council's procedures, you have to now commence a hearing in accordance with the hearing procedures to follow the due process, and then come to your conclusion following consultation with an independent person, which is required. When the investigation report was circulated, Councillor Turner, which obviously was entitled to do so, requested to be provided of the individual statements that had been taken by the investigator. So in addition to the investigator's report, you have annexes 1 down to 9, and you have those agreed notes of all of those witnesses that have been provided, and so you have that as well before you. In the update sheet, Councillor Turner made reference to the fact that we approached the witnesses and they did not wish to attend. That is correct. And on page 21 of your agenda, we provided you with the response from each of those witnesses so that you can see whether a response was received, and if so, what it said. On page 22, you're given some more information regarding evidence. So it's up to the committee to determine whether they have got sufficient evidence to make the decision or not. And it is for the council to govern its, the council has the right to govern its own procedures. On page 22 over to 23, you are it sets out what matters you must consider when reaching your decision. And again, makes reference to consultation with the independent person. And for this purpose would be Mrs. Malone, and the sanctions are there set out for you again. So, Madam Chairman, that's my presentation of the report for you to commence the hearing.
Thank you very much, Mrs. Hastings. Right. I would now like to open the hearing, and I will be reading 4 points on that. 1, the hearing has been convened in accordance with the Council's complaints procedure, and that an investigation has been conducted, the outcome of which is that it is considered there is evidence of a failure to comply with the Members' Code of Conduct. 2, the parties have been made aware of the content of the investigator's report and that this has been circulated to all members of the committee. 3, the monitoring officer has referred the matter for hearing because upon conclusion of the investigation, informal resolution was not considered appropriate for the reasons given within the committee reports. And 4, the purpose of the hearing is to consider the investigator's report, the evidence in support and representations from the parties. If the committee departs from the recommendations from the investigating officer and/or monitoring officer, detailed reasons will be required and which will be published in the decision notice. Right, now comes when we introduce ourselves. I'm Councillor Anne Wiggins, and I am the chairman of this committee. And if I take the councillors next, the subject member and his team, and then officers and the investigator last. I hope that's okay. We'll start with councillors.
Councillor Andy Baker.
Councillor Sarah Newton.
Councillor Michael Talbot. Councillor Maurice Alexander.
Councillor Daniel Lands.
Jane Watts, independent person.
David Irving, independent person allocated to assist.
Sue Galoni, independent person.
Councillor Turner.
Carol Cannon, supporting.
Ian Taylor, supporting Councillor Turner.
But just introducing myself. I'm Keith Simmons. I'm head of Democratic Services and Elections. Assisting the committee view of the position of the monitoring officer in the investigation. But would I just want to use the opportunity of speaking to say if everybody could use the microphones. I know it's a bit of a faff, but the audio, and certainly some members are using the induction loop, and that only really works with the microphone. That's why we're saying to people if they could use their microphone. Thank you.
Ian Ford, Committee Services Manager.
James Dwan, Communications Officer.
Karen Hayes, Executive Projects Manager, Governance, providing assistance to the committee.
Lisa Hastings, Monitoring Officer for Tendring District Council.
Melvin Kenyon, Independent Investigator.
Thank you very much. And also to add to what Mr. Simmons said, and to speak up as well, because it's very easy for it to sound as though it's whispering as well. We do want everyone to catch everything that's being said. Thank you. Falling foul of my own words. I will be calling on the investigating officer to present their report, but I've just got to read the 3 points here. 1, any document, evidence, or other material. 2, call such witnesses as considered necessary, and 3, make representations to substantiate the conclusion that the councillor has failed to comply with the Code of Conduct. This report and documentary evidence must be based on the complaint made to the council with no new points to raise or be raised. Right, I will now go over to I believe Mrs. Hastings is going to introduce Mr. Kenyon. Sorry.
That's fine. So I'll just formally introduce, for the purposes of this part of the hearing, will be undertaken by Mr. Kenyon.
Mr. Kenyon.
Okay, thank you, Chair. Good afternoon again. I'm going to speak for something less than 20 minutes. There may be some little repetition of what's already been said, for which I apologise. I'll start with a few words about the LGA Coastal Special Interest Group, or SIG, which is central to the complaint. The SIG has been around for at least 15 years and brings together representatives of 57 member councils and other significant stakeholders to, and I quote, champion the collective interests of coastal, estuarine and maritime communities. The SIG represents 16 million people in England and covers 60% of the English coastline. It's a well-established, well-attended, important group with many nationally known stakeholders, ministerial contacts, and considerable influence in central government. It has a high profile and national reach. The committee may wish to reflect on that when considering the complaint. Complaint is about Councillor Nick Turner's alleged behaviour at 2 virtual meetings of the SIG in June of last year. You'll have seen the wording of the complaint in section 5 of my report. I've done many standards investigations and written many reports. They all follow the same logical sequence. I set out my findings, the evidence on which I rely. Then I evaluate that evidence and draw conclusions from it. Finally, based on my conclusions, I make recommendations. I don't reach any conclusions without having the evidence to support them. There are 24 pages of evidence in my report. Section 7 presents evidence around the key question of whether Councillor Turner was in capacity when the events in question took place. Section 8 looks at the specific allegations against him and consists almost entirely of extracts from the summaries of my interviews with the individuals listed in section 6.2. Those included Councillor Turner and the complainant, Councillor Ernest Gibson, who is chair of the SIG and a member of South Tyneside Council, which is currently the lead authority for the SIG. The hearing procedure permits me to call witnesses, but I have almost never done that in any hearing, and I won't be doing it today either. Instead, I will allow the extracts taken from the witness statements in sections 7 and 8 to act as my witnesses. So with that in mind, I will assume that committee members have read the report and remind them of my conclusions, and I'll take questions after I've finished in on that. Presenting my conclusions, I'm sure the committee knows that I'm not required to demonstrate that a member has breached their code of conduct beyond reasonable doubt, which is, of course, the standard of proof in a criminal matter. At times, Councillor Turner's defence submission appears to present it that way, but in fact, I'm required to reach my conclusions based on the available evidence and the balance of probability, which you all know is a much lower standard of proof. And just before discussing my conclusions, I invite the committee to note 3 points. First, Councillor Turner's response to the complaint in section 5.2 of the report, where he apologises unreservedly for any offence given. His defence document, he describes it as a sincere apology. Second, when speaking to me, he described his own version of events, which you can find in section 8.2.10. There, he seems to confirm that his behaviour wasn't acceptable, though he does seem to dispute the effect that behaviour had on other people. And then finally, in his defence document, he acknowledges the unintended offence his comments caused. That seems quite unequivocal to me. So my conclusions. I'd first to decide whether Councillor Turner was acting in his capacity as a councillor when he attended the 2 meetings. As members will need no reminding, of course, under the Localism Act 2011,
Unless a councillor is acting in capacity, it cannot be held to have breached the code of conduct, no matter how reprehensible or even unlawful their actions might have been. Whilst the Localism Act is silent on what being in capacity means, there is some case law that helps us decide whether, in a given set of circumstances, a member can be deemed to be in capacity. We refer to some of that in our report, and also to the LGA guidance, which helps us interpret the Council's Code of Conduct. I was asked by the monitoring officer to consider the question of capacity particularly carefully in this instance, because the situation was less straightforward than might normally be the case. On the one hand, I had to consider the fact that the SIG was not recognised by the Council as an outside body, and that for at least 8 years, Councillor Turner had not been appointed as a Council representative on the SIG. So his involvement was not apparently official in the eyes of the Council. On the other hand, I noted that Councillor Turner had taken an active part in the work of the SIG for at least 13 years. He'd given the impression over those 13 years that he was there to represent Tendring District Council. He saw himself as a council representative and disclosed his membership of the SIG in his register of interests. The council paid the SIG annual subscription fees, and on occasion, council officers accompanied him to meetings. And Councillor Turner claimed and was presumably paid his expenses when he attended certain SIG meetings. So it appeared to us, based on the evidence and the balance of probability, that a reasonable member of the public with knowledge of all those facts would have concluded that Councillor Turner was acting as a tendering councillor and a representative of the authority when he attended SIG meetings, and those SIG meetings in particular. That was certainly the impression formed by the chair, the lead officer, and presumably tendering officers as well. Tendring District Council Code of Conduct was therefore engaged. We turn next to our conclusions about the allegations made against Councillor Turner. The 5th of June meeting was convened to gather feedback on a piece of software called the SMP Explorer tool, a short session led by Nick Hardiman, who is an officer of the Environment Agency. There were few invitees to the meeting. We spoke to only 4 individuals about what happened, one of whom was Councillor Turner. Based on that evidence and the balance of probability, the meeting does not appear to have progressed as intended. Councillor Turner was to some extent successful, repurposing or hijacking the meeting to instead discuss matters which were important to him. That appears clear, as does her irritation, from the comment made at the time by Hartlepool councillor Rachel Creevy in the MS Teams chat facility. It appears clear too from the evidence given by Councillor Turner himself. Even though there are few specifics about his exact words, Councillor Turner's behaviour at that meeting appears to have been unprofessional, poor and unacceptable. It indulged in a, quote, strong extended rant. Witnesses chose to describe him, amongst other adjectives, as being overzealous, obstructive, even aggressive. He was overly critical, talked over people, would not be calmed down, would not listen to reason, it was said. He would not allow the meeting to progress as it was intended to. Speaking somewhat generally, the complainant said, basically he is disruptive and has been for a long time. But on this occasion, he did overstep the mark. He really excelled himself. The lead officer said, his disruptive behaviour at meetings has become a consistent issue for us. Nick Hardiman echoed their observations, saying, and I quote, "I've found him to be someone who wishes to stir and provoke. His interventions have often been aggressive and have sought to rubbish what a person is doing." He commented that he was very unprofessional, crossed the line into unprofessional behaviour. The evidence also suggests that Councillor Turner made a personal attack on Nick Hardiman, something that Mr Hardiman confirmed to us. Councillor Turner appears too to have followed that by being, quote, personally abusive towards the lead officer. In making such personal attacks, he was damaging his own reputation and potentially that of the council and the SIG. He went beyond the protections afforded by Article 10 of the Human Rights Act, and we do not, in any event, consider that the context was political in the accepted sense of the word. And let's remember here that the officers being attacked, allegedly, are Mr Hardiman of the Environment Agency and Becky Lofts of the SIG. When we spoke to Councillor Turner, he suggested that his behaviour as described in the complaint was an exaggeration and was not sufficient to breach the code. At the same time, he seemed to be recognising, as I've said, that his behaviour had not been acceptable. However, he denied making personal attacks, saying they are being paranoid. In any event, he saw fit, as I've also said before, to apologise unreservedly for any offence given. When we spoke to Councillor Turner, we did not doubt that he feels strongly and passionately about defending the coastline in Frinton. Nor did we doubt, to use his own words, his unwavering commitment to his duties and the community he serves. But that isn't the issue. The issue is that it appeared to us, on the evidence available, that he'd failed to control his strength of feeling the 5th of June meeting. We therefore concluded that in behaving as he did, Councillor Turner breached the code of conduct by showing a lack of respect by attacking in a personal way two of those who attended the meeting, by failing more generally to respect others who attended. Behaving as he did, he brought his own role as a councillor into disrepute. In acting as he did, whilst he was a representative of the council on an outside body, brought the council into disrepute. Turning to the 29th of June quarterly meeting of the SIG, which this time had 49 attendees, we spoke to 9 interviewees, including Councillor Turner, about what happened. Based on their evidence and the balance of probability, it appears to us that Councillor Turner's behaviour was once again unacceptable and mirrored somewhat his behaviour on the 5th of June. The minutes of the meeting suggest that things did not run smoothly, with Councillor Turner the apparent cause. Interviewees referred to his derogatory comments about an external organisation. This time it was the RNLI. He again made what felt like a personal attack, this time on Ross MacLeod, who was at the meeting to represent the RNLI. Witnesses once more referred to Councillor Turner's unwillingness to be diverted away from trying to focus the business of the meeting on issues local only to him. Witnesses again spoke of his behaviour being part of a pattern over the years. Councillor Turner showed, quote, a low level of self-awareness and was, again, quote, oblivious to the offence he was causing. Witnesses said he was not helpful or constructive, was very rude, derogatory, offhand and disrespectful to others. All of those quotes. One witness spoke of him being in transmit mode. In behaving as he did in the eyes of some, he damaged the reputation of the SIG. This excuse me, this time in front of a much larger audience, as I've said, 49 people, some of whom had not attended previously. Once again, Councillor Turner felt that he had to apologise unreservedly for any offence given. Based on this evidence, we conclude that Councillor Turner again breached the Code of Conduct by showing a lack of respect by attacking a representative of an external organisation, this time the RNLI, in a personal way, and by failing more generally to respect others who attended the meeting. He went beyond the protections afforded by Article 10 of the Human Rights Act. We do not in any event consider that the context was political in the accepted sense of the word. In behaving as he did, he brought his own role as a councillor into disrepute, and in acting as he did whilst representing the council on an outside body, he brought his council into disrepute. However, on the 29th of June, Councillor Turner went further than he'd done on the 5th of June. His reference to Germans, intended as a joke, he said, went unnoticed by some of those we spoke to, though not by one attendee who is actually half German and was deeply upset by his joke. When we spoke to him, Councillor Turner did not dispute that he'd said something like, "Don't get me started on the Germans." But we felt that his references to Operation Sea Lion and pillboxes were very telling. The juxtaposition of those and the comments he made to us about his references to Germans appeared to us to betray an attitude that was rooted squarely in the Second World War thinking. This is in not some way an ageist observation, but instead seems to reflect his own comment to me, quote, "It's a different world and I just don't comprehend it any longer." His words, not mine. His derogatory references to swimming, floating, drowning, dress, Afro-Caribbeans and arguably Muslims caused very considerable offence and discomfort to some, though not all of those present. Councillor Turner did not appear to dispute that he'd said what he was alleged to have said, but he seemed to be completely oblivious as to how and why his behaviour had caused offence. On the one hand, some of our perhaps more charitable interviewees felt his opinions and views were old-fashioned and that they were more common perhaps a generation or two ago. On the other hand, there were those who went so far as to call his behaviour racist. He'd used a racial stereotyping, they said. At the same time, when we spoke to Councillor Turner, he's concerned that there were people of all kinds who visited Frinton who were, as he saw it, ill-equipped for and ignorant of the dangers of swimming in the sea did appear genuine. So, on the balance of probability, we tend to the conclusion that Councillor Turner made the remarks he made out of ignorance rather than malice, and that his language was clumsy and patronising, rather than being rooted in what might be described as out-and-out racism. Notwithstanding his motives, based on the evidence available to us and the balance of probability, it appears to us that Councillor Turner further breached the Code of Conduct by exhibiting discriminatory behaviour on the 29th of June. We agree with the words of one interviewee who indicated that even though she did not feel personal offence at what he'd said, Councillor Turner's behaviour had reflected badly on the community he represented as a councillor. In other words, in her opinion, he brought the council into disrepute. So in summary, based on the evidence available to us and the balance of probability, we conclude that at various times during the meetings of the LGA Coastal Special Interest Group, the 5th and 29th of June last year, which he attended in his capacity as a representative, Tendrick District Council, Councillor Nick Turner, 1, breached paragraph 1.1 of the Tendring District Council Code of Conduct by failing to treat other councillors with respect. 2, breached paragraph 1.2 of the code by failing to treat local authority employees and representatives of partner organisations with respect, and failing to respect the role they play. 3, breached paragraph 2.3 of the code by failing to promote equalities and behaving in a discriminatory manner. And 4, breached paragraph 5.1 of the code by bringing his own role and Tendring District Council into disrepute. Thank you for your attention.
Thank you, Mr. Kenyon. Can I just confirm that you have presented all your evidence and that there are no witnesses? Just for clarification, please.
I will not be calling any witnesses.
Okay, now we will have questions from Mr. Turner or his representative, and I've just got a couple of things to read before that can go ahead. The respondent councillor or their representative may question, not cross-examine through the chairman. 1, the investigating officer upon the content of their report, and or 2, any witnesses called by the investigating officer, which there are not. This is solely the councillor's opportunity to ask questions rising from the investigator's report, and therefore not to make a statement. Okay. Right. Okay, and I believe I'm being told that it's you, Mr. Cannon.
Yes, that's
okay,
right.
Thank you very much.
Thank you, Madam Chairman. Okay, I've been told that I have to address all questions to the chair, so I do apologise for any inconvenience there. The first thing that I would like to raise is this question of capacity, which the committee is being asked to resolve. One would have expected that that would have been resolved earlier in the proceedings. There's no argument that Councillor Turner...
Excuse me, Mr. Cannon, is this a question to the investigator?
Yes.
Okay.
And there's no argument that Councillor Turner believed he was acting in capacity, but shouldn't the investigator have actually obtained actual proof of that?
Mr. Kenyon? Microphone.
I understand the question correctly. That's what I've done in this report. If I carry out an investigation, the first thing I have to assure myself of is that the member in question is actually in capacity. There are occasions, for example, on social media, using social media when there can be an issue over that. But in this instance, the question revolved around the fact that the council had not formally recognised Councillor Turner as being in capacity. So it isn't my job, as it were, to decide before an investigation starts whether somebody is in capacity. It is my job as part of the investigation to decide whether whether a member is in capacity. And that's what I've done here.
Thank you, Mr. Kenyon. Mr. Cannon.
Fine. So it's accepted that, sorry, Madam Chairman, that there is no actual evidence or proof that Councillor Turner was acting on behalf of the council.
Is that a statement? Oh, it's a question, Mr. Kenyon.
No. He was in capacity based upon the evidence available to me as an investigator. Councillor Turner was acting in capacity. And I think you've just said that Councillor Turner has accepted that he was acting in capacity. The argument for his being in capacity I put forward in my statements a few moments ago, and that's argued more fully in the report. So Councillor Turner was in capacity, in my opinion, based on the evidence available to me and the balance of probability. And I think you're saying that Councillor Turner accepts that for the last however many number of years that he's represented Tendring District Council on the SIG, he was acting as a representative of the council. So no argument, he was in capacity.
Thank you, Mr. Kenyon. Mr. Cannon?
And if I can move on to another question, Madam Chairman. Could we inquire where Mr. Kenyon set the bar for standards of behaviour, bearing in mind it is a very subjective issue, and what is acceptable to one person will not be acceptable to another, and why in the final report he did not highlight inconsistencies in the witness statements in this area.
Mr. Kenyon?
I've set out, and I accept that. I'll give the example of bullying. That is a good sort of yardstick, and we're not talking about bullying here, but I will give it. It's a good example, I think. There are those people who believe that if somebody says boo to them, they are being bullied, and the view that we take of that I take of that when I carry out an investigation, is that I think we need something rather more than boo for somebody to be bullied. What I have done is set out in the report the guidance that accompanies the model code that was adopted by the District Council, which provides, if you like, a yardstick against which to measure people's members' behaviour. And that is what I have relied upon. I think that guidance is very helpful. I can't quote it verbatim, but it's there in the report. And that helped me decide. Plus the fact that there were quite a large number of people there who said that his behaviour was unacceptable. There were one or two who weren't quite as offended, but the majority of people to whom I spoke were quite clear that there had been personal abuse, and that Councillor Turner had gone further than was acceptable in that kind of forum, in the words he used towards people and in his behaviour. So the yardstick, if you like, is set out in the report and is extracted from the guidance that accompanies the LGA model code, which is the code that Tendring District Council adopted. As far as the other point was whether I drew out whether there were individuals who didn't share that view. I think I did draw that out. I may not have explicitly written a sentence that says that, but it's quite clear from the evidence. The evidence hasn't, as it were, been withheld. It's there in the report. And so as far as I'm concerned, Councillor Turner went further than he should have done and breached the code.
Thank you, Mr. Kenyon. Mr. Cannon?
Thank you, Madam Chairman. Okay, I would also like to ask Mr. Kenyon about the percentage of attendees at the June 29th meeting responded. There was a total of 9, including Councillor Turner, one of whom did not sign off his statement, but it has been included in the report, which is a concern. But in total, there were 49 attendees at that meeting. Some of the others were contacted and declined to submit a statement. One in particular was present at an after-meeting discussion between Becky MacDonald-Loss and Ross McLeod, and she has refused multiple requests to give a statement or attend as a witness. I'd like to hear Mr. Kenyon's views on that, please.
Mr. Kenyon?
First of all, there's a question of proportionality. There is a cost to the council in carrying out an investigation. If I'd interviewed all 49 people or attempted to do that, I'd probably still be interviewing them. So that's point number one. Point number two, I can't force anybody to, as it were, submit themselves to an interview by me. I can't do that. And point three is that whether an individual chooses to take part shouldn't be taken as an indication of anything other than that either they've got nothing to say or perhaps they're uncomfortable with the process. I find people who are uncomfortable with the process all the time. They just won't take part, even if they are important to the process. And I have no power to force them to do it. So 9 people out of 49, given that there are complaints that I investigate where there are 2 or 3 people, seems to me to be a reasonable number. I did try and interview more, but for various reasons given, I wasn't able to do that. But I think 9 people, certainly as far as the 29th of June meeting is concerned, is more than enough to form a judgment, and that's what I've done.
Thank you, Mr. Kenyon. Mr. Cannon?
Thank you, Madam Chairman. The next question concerns the format for the meeting. These were online Zoom or Microsoft Teams meetings, I'm not sure which. But the facility to manage these type of online meetings is available to the administrator. It is very difficult when you have a situation like this to be sure how much was caused by the poor management of the online meeting and the poor chairing of the meeting, and how much was down to Councillor Turner's exuberance. So could Mr. Kenyon please sort of tell us what allowances he made, because these were an on.
Okay. Mr. Kenyon?
I made no particular allowances. It was a meeting. What's true is that let's call it the Secretariat or the Constitution of the SIG, apparently at that time didn't allow them to, as it were, mute individuals. My understanding is that after the second of these meetings, I think in September, and I think it may be in response to one of the questions that's been asked, they changed the constitution or the standing orders or whatever they call them to enable them to mute or to exclude somebody. And that was done in direct response to what had happened on the 5th and 29th of June. So I'm afraid I can't be in the mind of the Secretariat as to why they did or didn't try to manage it. But it's certainly the case that they believe they didn't have, as it were, the formal ability to exclude Councillor Turner at that time.
Thank you, Mr. Kenyon. Mr. Cannon?
Thank you, Madam Chairman. Could I inquire of Mr. Kenyon whether he actually established what facilities they did have?
I don't understand.
In controlling the meeting, what were they using? Sorry, I didn't finish my question.
They obviously they were using Microsoft Teams, I'm not an expert on Microsoft Teams, but I do know, as I said a few moments ago, that they did not have, they felt that they hadn't got the right, as it were, to exclude Councillor Turner. So short of Councillor Turner switching his own feed off, I imagine that they haven't got any wherewithal to do it, but I'm afraid I'm not a Teams expert.
Thank you, Mr. Kenyon. Mr. Cannon?
Okay. Next question. Sorry, Madam Chairman. I would like to inquire how Mr. Kenyon maintained impartiality in his report and avoided favouring the officers against Councillor Turner. I said I would like to inquire how you maintained impartiality in the report, avoided favouring officers against Councillor Turner.
It's what I do. Can't really say anymore. I have no stake in the outcome of these things. It sounds like the wrong words to choose, but actually, apart from wanting to make sure that the evidence tells the story, I don't, as it were, care what the outcome is. I have no skin in the game. So what I do is I gather the evidence, I write the evidence up, and I draw conclusions based on that evidence. When I carry out investigations, and I've done a lot of those over the past few years, I can confirm that it is not the case that every investigation that I do results in a breach of the code. So I balance the evidence available to me. As far as I'm concerned, the clue is in the word, it is in the job title, which is independent.
Thank you, Mr. Kenyon. Mr. Cannon?
Thank you, Madam Chairman. This is my final question. Sorry, excuse me once. Right, Madam Chairman. The concern is that in drawing his conclusions from the evidence, from the what occurred, did Councillor know or realise that he was in breach of the?
Sorry, I didn't understand the question. Could you repeat it, please?
I'll thank Madam Chair. Did you?
Mrs. Kenyon.
Madam Chair.
Yes, okay.
I do apologise. The question to the investigating officer is, during his investigation and going, obtaining the witness statements, and in summing up, when he was doing the summary, subsequent to obtaining this evidence from the complainants and statements, did he not draw a conclusion in relation to whether or not Councillor Turner was aware of the breaches in this behaviour, alleged behaviour?
If I've understood correctly, I take you back to what Councillor Turner said in his response to the complaint, which was, first of all, I think twice, he apologised wholeheartedly for any offence given. And he didn't really dispute that these events had taken place. The question in his mind, I think, was whether he had caused offence or not. And the witnesses that I spoke to said that most of them said they had been offended, or they had seen how offence could have been caused by what he said. So I think Councillor Turner himself has agreed that there is a need to apologise. He's used, I think, in his defence document, the words sincere apology. So I think, to answer your question, if he didn't know it at the time, he does now.
Thank you, Mr. Kenyon.
Sorry. So at the time of this report being written and this investigation being conducted, he wasn't aware. Do you concur with that conclusion?
I think you'd have to ask Councillor Turner that. I don't know what was in Councillor Turner's mind.
I'm asking the investigating officer because he has drawn the conclusion. If you don't know the rule, you don't know the rule that you've
okay, yes. He signed his acceptance of office. He'd had training on the Code of Conduct. And in signing his acceptance of office, then he, as it were, signs up to the Code of Conduct.
Thank you.
Have you finished your question?
I have one more, Madam Chairman, if I may.
Okay.
I do beg your indulgence. Okay, the final question that I have for Mr. Kenyon relates to the allegations in the witness statements that appear in the final report concerning Councillor Turner having racist views, when there is actually no substantial evidence to support that. Why do they still appear in the final report? There is a reference in Becky MacDonald-Loss statement to a police referral, which is now contradicted in her answer to the questions that were subsequently submitted. And I believe there was a referral to the police from the monitoring officer, but no action, nothing has occurred. So why is that still in the report and now in the public domain?
Microphone.
Not used to this. I think it was put into the public domain in the first part of this hearing today, but I'm required to investigate it because that was one of the allegations. I'm just trying to find what I said a few moments ago, and that was, on the balance of probability, we tend to the conclusion that Councillor Turner made the remarks he made out of ignorance rather than malice, and that his language was clumsy and patronising rather than being rooted in what might be described as out and out racism. That was the conclusion I reached in the report. There were those who were of the view that Councillor Turner's remarks were racist, and there were those who were, let's say, less convinced. I think I used the words more charitable, but the conclusion I reached was he said what he said out of ignorance rather than malice. His language was clumsy and patronising rather than being rooted in what might be described as out and out racism. I'm not sure I can say much more, and that's in the report on page 77 of your pack.
Thank you, Madam Chair.
Can I just clarify a point, sorry, page 77 of the blue pages.
Councillors are looking for that now.
Madam Chairman, I didn't cover the matter of the police there and then because that's really outside the scope of my investigation. It isn't for me to do what police ought to more probably have done.
Thank you, Mr. Kenyon. Oh, yeah, okay to proceed? Right, can I just confirm that you've asked all the questions that you wish to ask of Mr. Kenyon, please?
Yes, Madam Chairman. Thank you.
Thank you. Right, carrying on, I will just read the next bit of text. That members of the committee may question, not cross-examine, through the chairman, 1, the investigating officer upon the content of their report, and or 2, any witnesses called by the investigating officer, of which there are none. This is the committee's opportunity to ask questions arising from the investigator's report, but not to make statements. Okay. So if you'd like to raise your hands when you want to ask a question, I can put your name down and then hopefully get you in the right order. Councillor Land.
You have to excuse my ignorance if it is documented in parts or some of this extensive text we've got in front of us, but was it clear to the authority, I think it's to you, Lisa, really, was it clear to the authority that this was an official outside body that we had a representative on?
Mrs. Hastings.
I was just going to ask whether the committee wishes to depart from its procedure and ask myself questions rather than the investigating officer, because the hearing procedure is the questions to the investigating officer, which the investigating officer has covered this in his report, but I'm just asking the committee whether you're wishing to depart from your procedures at this stage.
Are you willing to answer any questions that they might have, whether it is of yourself or of Mr. Kenyon, the investigator?
My personal view is, because I like to uphold the governance of this council, is that we should stick to the procedures that the committees have agreed.
Okay.
So any questions I believe should be put to the investigator, who I believe has covered off this point in the investigation, but I feel departing from the procedures is not the right thing to do.
Thank you for your advice, Mrs. Hastings. Microphone.
It would be fantastic for me as an investigator if what incapacity means was codified in the Localism Act. It's not. There is some case law, a little bit of which I referred to in my report, and there is other case law as well, which I haven't referred to in my report, which predates the Localism Act, but is still relevant as far as legally relevant as far as interpretation is concerned, which we use to help us decide whether something is somebody's incapacity. Prima facie, if a member has attended a council meeting and is standing up at that council meeting speaking, or if they're on a committee as they are today, they're acting incapacity. But there are occasions when it isn't as clear cut. So the ones that I am often called in to make a judgment on are especially around things like social media, where the boundaries between a member acting in a private capacity and in their capacity as a councillor are less clear. In this instance, I have, as Mrs. Hastings has said, weighed the evidence up to arrive at a conclusion as to whether Councillor Turner was in capacity. He has agreed that he was in capacity, and without wishing to put words into his mouth, I think he would be somewhat disappointed if the contribution that he made over the years he was actually attending the SIG as a representative of the council. He wasn't actually doing it in his capacity as a councillor. So I've put forward the evidence in section, is it 7.1? 7.1 of my report. That, if you like, is my argument structure as to why he was in capacity. If somebody signs there an email, Councillor Nick Turner, it doesn't necessarily mean that he's in capacity. Equally, if he signs it Nick Turner, it doesn't necessarily mean that he isn't in capacity. What's important is whether he is doing the business of the council. And in this instance, he was doing the business of the council. And things that the council did, like paying his subscription fees, like paying his expenses, are a recognition that at some level he was recognised as a representative of the council in the eyes of authority. Does that answer your question? Is that enough to answer your question?
Can I come back? Yeah, I fully understood from your report the where we arrived in terms of him being acting. I think my question came more about as whether or not the authority, because that particular group that he attended, this was potentially the first I'd ever heard of it when I was reading some of this information. So for me, it was just, I was slightly unclear as to whether this was a very formally recognised panel, outside panel, that this council had put someone on and was very aware that someone was attending regularly and contributing. That was kind of the question. That's why I went to Lisa, but you might not know the answer.
I can't say I do. I've used the evidence that's available to me. It's certainly, as I said at the beginning, an influential, nationally recognised group. It's got the Environment Agency, the RNLI, the Peer Society, the Marine Management Organisation, and other bodies on it. So it is it's not, as my grandmother would have said, a tuckney-halfpenny organisation. It is a national organisation with reach right into government.
Councillor Land, if you were to look at pages 46 and 47 of the blue report, I think you might find some of the answers there. Thank you. Councillor Baker, did you want to ask a question? No? Any other councillors like to ask Mr. Kenyon a question? So we'll move on to 12, the respondent councillor's case. The respondent councillor or their representative may present their case, call any witnesses as required by the councillor or their representative, and make representations as to why they consider they did not fail to comply with the Code of Conduct. Councillor Turner or Mr. Cannon?
Thank you, Madam Chair. Okay. I would like to just draw a couple of observations at the start. One is an extract from the guidance on the Local Government Association Model Councillor Code of Conduct, which states under respect. You will engage in robust debate at times and are expected to express, challenge, criticize, and disagree with views, ideas, opinions, and policies. I'm sure you're all aware of that. And it is important that we recognise that Councillor Turner has devoted a lot of time and energy to studying his subjects, especially in this area, which is very close to his heart, and he is very well informed and able to challenge the experts. The second observation that I would like to make concerns sorry, I've lost my place. The witnesses having declined to attend, especially the complainant himself. We did request that all the witnesses who gave statements attended, but as you've already been informed, none of them have. This could be seen as depriving Councillor Turner of a fair opportunity to question those accusing him. Right. Now you've all received the electronic copy of Councillor Turner's defence submission. You'll be pleased to know I'm not intending to read all of that to you. I'm just going to summarise the main points. I think it's very important to take into account Councillor Turner's 25 years of dedicated service. He has done a tremendous job for his community over the years. He has consistently exhibited professionalism, even in the most heated debates. His responses, though strong, were in line with the robust nature of council discussions. He has shown a willingness to engage and rectify any perceived breaches of conduct, reinforcing his respect for the council standards. Demonstrating his integrity, Councillor Turner has actively sought to mend fences whenever his actions were perceived as disrespectful. His apologies and efforts to engage in dialogue with affected parties underscore his commitment to fostering a harmonious working environment. Councillor Turner has been misrepresented in relation to his commitment to equality. His proven track record of actively participating in initiatives aimed at enhancing inclusivity starkly contrasts with the accusations of discriminatory behaviour. Notably, he has experienced ageism, a protected characteristic that was conspicuously absent from the investigating officer's final report. Moreover, the discussions perceived as discriminatory were in reality valid and necessary engagements in policy advocacy designed to promote community safety and equality. Addressing sensitive issues concerning Afro-Caribbean and Muslim communities, although challenging, is essential for the comprehensive dialogue and improvement. Councillor Turner should be commended for his bravery in bringing these crucial topics to the forefront, fostering a necessary discourse that many might avoid due to its complexity and sensitivity. The defence strongly contests the idea that Councillor Turner's actions have brought disrepute to the council. His conduct has consistently aimed at advancing the community's interests, often being misunderstood in the complex situations that are part and parcel of his remit. The defence has pointed out significant procedural differences that impact the credibility of the allegations. The lack of clear attendance records at key meetings shows an unprofessional approach to the proceedings. The absence of a definitive recording of the meetings, a function which is available in both Zoom and MS Teams, means that the investigating officer's findings on a balance of probability are based on subjective rather than objective information. The substantial delay in filing the complaint, 72 days from the first meeting and 48 days from the second, suggests a lack of urgency or severity, which questions the motives behind the allegations, especially as one of the SIG officers who was party to the discussion between Ross McLeod and Becky MacDonald Loss, namely Bethany Hanson, after the 29th of June meeting had ended, has refused to give a statement or appear as a witness, despite multiple requests. At the 5th of June meeting, there are no minutes or attendance records available. At the 29th of June meeting, of the 49 attendees confirmed in the minutes, only 9, including Councillor Turner, provided statements. Others either refused or stated they had nothing to report. Councillor Turner has actively engaged in critical discussions about safety and policy, particularly concerning coastal management, reflecting his commitment to public welfare. His remarks have sometimes been taken out of context or misunderstood, detracting from the substantive issues he aimed to address. The defence asserts that any controversial remarks made by Councillor Turner were aimed at improving community safety and were not intended to offend. His immediate apologies for any unintended offence highlight his responsiveness and accountability. Considering Councillor Turner's long-standing dedication, the procedural gaps in the investigation, and his efforts to address the concerns raised, we urge a reassessment of the charges. It is crucial that a committee's judgment reflects a balanced view of his intentions and the factual context of his actions. Also, his capacity at these meetings remains a point of contention at this time. Councillor Turner's robust and challenging contributions to debates are not only a fundamental aspect of his role as an elected official, but are also protected under UK law, specifically under the principles of freedom of speech as enshrined in the Human Rights Act of 1998, which upholds the right to express opinions freely without interference, a crucial element for effective democracy and governance. Thank you for your attention to this matter.
Thank you, Mr. Cannon, and I'm just making sure that you've said everything that you want to say at this point.
No, I have nothing else to add.
Okay, thank you very much. Mr. Kenyon.
Questions, please, Chair. You referred just a few moments ago about, and I quote, procedural gaps in the investigation. Can you explain to me what the procedural gaps in the investigation were, please?
Thank you, Madam Chairman. Yes, the procedural gaps relate to the lack of a definitive record, the lack of attendance records, the lack of minutes, which don't seem to have been given due weight, in our opinion.
Mr. Kenyon. Microphone.
I would just say I'm not convinced that those are procedural gaps in the investigation, but I'll ask my next question. And there were minutes, I might point out, of the second meeting. How do you think that Councillor Turner's expertise and undoubted commitment to his role as a councillor in the community are relevant to the complaint and relevant to whether he breached the code? As one would hope that he wouldn't be the only member who was committed to his community and had a certain amount of expertise. How do you think that they are relevant to the committee's consideration of the complaint, please?
Mr. Cannon.
Thank you, Madam Chairman. I think the point here is that in the presentation by the RNLI, which seems to be a substantial part of this case, it is alleged that there was a dispute on fact between Councillor Turner and Ross McLeod. So you have to consider whether Councillor Turner was in actual fact correct, he was saying, which, if that had been accepted by Ross McLeod, would have not led to the dispute. And that does not seem to have been considered.
Ms. Kenyon.
Can you please point to where there is evidence of a dispute between Ross McLeod and Councillor Turner? Until I read Councillor Turner's defence submission yesterday, I haven't encountered any suggestion that there was a dispute between them, rather that it was Councillor Turner who launched a personal attack on Ross McLeod. So can you please point me to where in the evidence that I've put forward there is evidence of a dispute between them?
Mr. Cannon?
My colleague.
Madam Chair, may I take
Okay,
that
yes.
question?
Yes, of course.
There clearly was a dispute on that occasion and that meeting. And Ross McLeod here also goes as far as to say very clearly that he didn't go so far as to attack me personally. He made that statement very clear. There was most definitely a difference of opinion at that meeting involving
Excuse
Ross
me,
McLeod and others.
can we have a page number, please?
It's a quote from Ross McLeod's witness statement. So I haven't got it to hand, but it's there.
Ross, I think it starts on page 99 of the blue pages.
Yes.
Sorry.
Ross McLeod's witness statement is on page 57 of the blue document.
Okay, page 57 is. Oh.
Yeah. The full statement is on page 99.
So the full statement is on 99 and the summary is on the 57.
That's in Kenyon's report, but the full statement is on 99. It's just the summary of it is in page 57.
Thank you.
Well, the dispute between the two of them went on over the lifeboat and on the issue of the Black Swimming Association and their role with that. Now, I've quoted verbatim from him here, which is, he didn't appear to take any of that on board and was in transmit mode. He said that the materials did not reflect those who were drowning in his area, though he didn't go so far as to attack me personally. So it's a clear statement from Ross McLeod that he didn't feel attacked personally at any stage, despite a difference of opinion.
Sorry, what was the question?
Do you know? I can't remember.
Was about whether there was a dispute.
Chairman, with your assistance, I think I found it on page 101 of the blue papers. It's about 3/4 of the way down, and the paragraph begins, he didn't appear to take any of that on board. Mr. Taylor can just confirm that we've got the right, yes, we've got the right paragraph.
Yes.
That's the one.
Thank you.
Was the top of that said he made me feel uncomfortable as well. But I've not heard that there was a dispute. Some kind of argument, and I don't think anyone has suggested until today that there was an argument.
Would you think the words "he didn't take any of that on board" don't imply that there was some difference of opinion going on?
I don't believe that it shows that there was a dispute. What I think happened was Ross McLeod presented material about, what's it called? It was a day about a drowning prevention day that they were going to hold from memory. And Councillor Turner interrupted what he was saying and made Ross McLeod feel uncomfortable and attacked him. So I don't think that equates to a dispute, but it may be that we just have to accept that there's a difference of opinion. I do have another question.
Madam Chairman, I think we do have to agree to differ on that. I think that when somebody disagrees with you, it's a dispute. And it may not be a major dispute, it could be a minor dispute, but something's being disputed.
Okay.
My next question is, how do you believe that the undisputed, and by that I mean Councillor Turner, hasn't disputed the comment, "Don't get me started on the Germans," supports the view that he was not discriminatory during the 29th of June meeting?
Well, I think that the comment, "Don't let me get started on the Germans," I mean, what does that mean? How is that discriminatory?
I think it's for you to tell me. Why is it not discriminatory?
Well,
Don't
the
get me
should be on you to
started.
say why
Don't get me started on the Germans. Doesn't sound to me to be.
Can you stop, please? Both stop.
Sorry, Chair.
We're in the procedure for any questions.
Oh.
So that's where.
Apologies, and I am answering it on the grounds that I think the answer to that is that the question needs to be asked. Why is that discriminatory? There is nothing intrinsically discriminatory about saying, "Don't let me get started on the Germans." He could be referring to a time in a holiday camp or a hotel. He could be referring to football. It could be anything. In this occasion, he was referring to something else in a sort of, jocular manner. I don't think this issue indicates anything to do with discrimination against Germans or people of German descent. He had no idea that somebody there was half German. He hadn't deliberately gone to offend anybody. He just made a comment in relation to the coast, where there are pillboxes and reminders of the Second World War, but currently there's a large German company planning on bringing cables and electricity aboard at the coast that are unwanted because of the nature of that delivery mechanism, which is large above ground pylons. That's the area of dispute. It's a well-known dispute throughout the east of England at the moment, and it was a light-hearted remark. He had no idea that the person there was half German, and so he wasn't trying to offend, he was just making a reference. And I think if we come to that, then we're all in trouble.
Many more questions?
No.
Right, members of the committee, you can make question but not cross-examine through the chairman, the respondent councillor and all their witnesses, of which there are none. In any instances, only questions may be permitted to the allegations and the respondent councillor's case, and no statements to be made. Councillor Alexander.
Chair, the question or questions I have is for clarity for my own mind. Right. So my question to Councillor Turner, if I may.
Yes.
Thank you. Is that did you at any time during your long time that you served on SIG have any knowledge that you were not there in an official capacity?
I'm answering on behalf of Councillor Turner, if that's okay, Chairman.
Yes.
I think it's quite clear Councillor Turner did believe that he was acting for the council. That isn't in dispute. It's whether that what he believes is actually correct. It's very well to believe I could believe that I'm a leopard, but that may not be correct. You know, we have to sort of delve a bit deeper into that to find out whether that capacity really existed. It's something that's a bit of a moot point really here, because we've attended, because we feel it's important for Councillor Turner to respond to the allegations. You know, otherwise he'll have no opportunity to answer. It's also important that he fulfils his obligation to go through all the council's procedures in this matter, because this issue of capacity will have to be decided at some point, perhaps at a higher level.
Thank you, Mr. Taylor.
So to relitigate then, at no time did you, Councillor Turner, believe that you were not a member of the SIG committee? That was the question, Chair.
Mr. Taylor?
Councillor Turner did believe he was a member of the SIG.
Thank you.
Chair, permission to...
Yes.
Right. At any time, did you receive any training in respect of sitting on that committee, or what the expectations of tendering district council to you would have been at that time?
If I may answer again, Chairman. Councillor Turner didn't receive any training in relation to this committee. He's received no committee reports or policy statements or anything to guide him in his role in this committee, which is one of the reasons why we feel that the capacity issue is relevant. Usually when members are appointed to outside bodies, they have policies agreed by cabinet or officer decisions or portfolio holder decisions to support them. There's nothing in this case. It would indicate that Councillor Turner, although believing he was representing the council, wasn't. He was attending as a local person with an interest in coastal matters who'd been invited to this committee a number of years ago, and they're arrested. There's absolutely no governance from the council associated with this at all.
Mr. Taylor. Hello.
Okay, once more, Chair, if I may, to relitigate. Yep. So there was no training undertaken, which, if I may move into my last question. So with no training and undisputed the enormous amount of knowledge you have within this whole sphere, how did you see your role there, and what were you to bring to that committee?
Councillor Turner believed, sorry, Chair.
Sorry, do carry on.
Councillor Turner believed that his knowledge of, Councillor Turner's always masters his brief. I mean, my experience of knowing him over a number of years is that one of the greatest respects he does show to all officers is that he goes off and learns what he's talking about and studies it. Now, he was asked to attend this group over 13 years ago. And throughout that time, he's listened, learned, done his research, and he's well aware of the issues at stake. And the issue at stake on this particular meeting on the 9th of June was about the shoreline management plan. And what happened, unfortunately, was a bit of a mess up, really. He believed he was there at a normal meeting to discuss the shoreline management plan, when in actual fact, it was a training session designed to be shorter and more brief. And that's why it got muddled. The meeting wasn't handled well. People spoke over each other in order to try and get their point across. And that's the situation that it was.
Mr. Tate. Other councillors got any questions?
Thank you. That was really where I was trying to go earlier, and thank you for pointing me in the right page. But I just, it confuses me somewhat that we weren't aware, or we didn't have it known or made known that this group or this committee that Councillor Turner was attending, it just seems it was an unknown to the authority, and it just continued in goodwill over time and knowledge and experience. Yeah.
That's it. Sorry. Yes, I know what Mrs. Hastings is going to say.
Yep, this is point of procedure for questions of Councillor Turner and his representative, not for statements.
Yes. Thank you. I'm just about to say, which isn't on the in the procedure, that if you're willing to go down to agenda item 15, that we carry on up until agenda item 15 before we break for lunch. If everyone is happy with that. Please say now if you're not. Everyone happy? Nod of the head would be nice. Sorry, Councillor Turner, are you happy with that?
Yeah. Thank you, Madam Chairman. Yes, we are.
Thank you, Councillor Turner. Sorry. Mr. Kenyon, are you happy with that?
Yes, yes.
Thank you very much. Okay, right. Further on than I thought. Okay, summing up. The investigator may sum up the complaint, and then the respondent councillor may sum up their case. Oh, sorry. We've reached the point where summing up that there are summing up submissions. Before proceedings further, may I remind both the investigator and the subject member that no new material can be introduced in the summing up, so it's just what's gone on already. And I'll start with Mr. Kenyon, please.
To add very much to what I've already said, the matter of capacity for me on the balance of probability and on the evidence available is not in question. I think Councillor Turner himself believed he was a representative of the council. Everybody who attended that meeting, those meetings of the SIG, believed him to be a representative of the council. The council paid the SIG's subscription fees for Tendring District Council, and Councillor Turner claimed expenses from the council for his attendance on occasion at SIG meetings. Now, clearly these two meetings were virtual, but we know that he claimed expenses. So we could get into a semantic discussion about what the council means. But it does seem to me that paying the subscription fees, sending council officers along with Councillor Turner when he attended meetings, paying his expenses when he claimed them, does indicate some kind of acceptance on behalf of the council, whatever that means, that Councillor Turner was in capacity, quite apart from the fact that he agrees he was in capacity. I have set out the fact that based on the evidence available and the balanced probability, there are 4 breaches of the code. I won't repeat them. I think we've heard them several times over. But what I will say, finally, is this is not about Councillor Turner's service as a councillor over the year or his public service more generally. This is about issues during those 2 SIG meetings that arose. Those are set out in my report. I've drawn conclusions on the basis of the evidence available to me, and I have concluded that Councillor Turner breached the code of conduct. Thank you.
Thank you, Mr. Kenyon. Mr. Cannon or Mr. Taylor?
Yes, thank you, Madam Chairman. It's me this time. I would like to sort of try and sum this up as best I can, and as succinctly as I can, but please forgive me if I do run on a bit longer than Mr. Kenyon. Just to give a bit of background, I am a former head of service at this council, and I was a local government officer for the best part of 40 years. So I have got a considerable experience of meetings, attendance at meetings, members at meetings, and so forth. When I was asked by Councillor Turner if I could offer any advice and support for this, sorry, I am going to come on to the questions. Okay, well, we've heard the 4 allegations. I won't repeat them again for brevity. What I will do is go straight to the meeting on the 9th of June and the investigation officer's conclusions of that.
5th of June.
It was June the 9th, I thought. No? Is it 5th June? 9th?
5th of June.
Beg your pardon. 5th of June, where the conclusion of the investigating officer was, in behaving as he did, we conclude that Councillor Nick Turner breached Tendring District Council Code of Conduct by showing a lack of respect by attacking in a personal way 2 of those who attended the meeting, and by failing more generally to respect those who had attended the meeting. And in behaving as he did, he brought his own role as a councillor into dispute. So the dispute here is, how did he behave? How was his behaviour so reprehensible as to meet the criteria for this allegation? He's acknowledged himself that he's enthusiastic about this subject, wanted to talk about it. He's acknowledged himself that he wasn't fully aware of the purpose of the meeting. But nobody at any stage has claimed a personal attack. Nick Hardiman, who was the Environmental Agency's representative there, I won't go verbatim on it, but I've got a quote from here. He says, but he doesn't remember some of the things that were said. So he's not clear on it because there are no records of the meeting, no recording of the meeting. These are all just people's personal remembrances some considerable time later. I think it was 3 months or more before this complaint was officially made. So people are recording that. They're saying, I don't remember what was said. Well, at the time, I thought, well, that's just Councillor Turner. I know he doesn't like or agree with and hasn't signed up to the shoreline management plans. He appears to be something of a climate change sceptic and dislikes some of the things we're trying to do in the plans. His attacks have tended to be against the plans themselves. I think that's a clear statement from this officer. They didn't feel personally attacked, but it's about the plans that he was representing. I know there were further comments from Mr. Hardiman in the investigator's report that says that, or if a more junior officer had been there, they might not have liked it. but I'm robust enough to do so. Well, it's my experience you don't send junior officers to meetings at a high level, and of course they wouldn't expect it. I sent my 5-year-old niece there, she wouldn't like it. But the point is that senior officers were there, and they should be robust enough to engage in a discussion of serious importance. The claim that Councillor Turner was irritated other people and citing the use of the chat room at that meeting is also something I'd like to dispute. The message that was conveyed on that chat room was basically just a reminder to Councillor Turner or anyone who was looking that it was intended as a training session. They didn't say anything about how rude or this is unacceptable or how outrageous or I'm offended. It just merely said that this is a training session. Now, this is where we're trying to get some perspective on what was actually said at this meeting and how offensive it was. Councillor Turner has acknowledged that he's extremely concerned about the Environment Agency's shoreline management plan. And I think it would be incumbent on all of us from this area to be concerned about their shoreline management plan, which essentially says we'll wait and see what happens and we might do something about it if it occurs. Which, for those of us who remember or have been involved in commemorations of people who've died in this area as a result of the sea coming in, I think it's incumbent for us to be take this a bit more seriously.
Okay.
Okay, well, this session, and the point I'm trying to make is I don't believe for 1 second, and there's no evidence to support, that Councillor Turner overstepped the mark at this meeting. He misunderstood its purpose. The people who were running the meeting didn't handle it badly, and they were frustrated because they'd organised a 1-hour meeting for a training session, always risky in my experience, but nevertheless. And there was no complaint arising from this meeting at the time. It was finished, it was done and dusted on the 9th of June. No reference to it was made until 3 months later.
5th June.
Oh, I beg your pardon, I'm sorry. I'm a bit dyslexic about that. It's going to stick now, it's always going to be the 9th to me. But really, I'd like to move to the meeting of the 29th. Have I got that one right? It's on the 25th, is it? Oh, good. So again, the investigation officer stated that based on the evidence, he concluded Councillor Turner breached the Tendring District Council Code of Conduct. And again, by attacking a representative of an external organisation in a personal way. Well, there's no evidence to support this. In fact, as we discussed earlier in the questions, Ross McLeod, the person representing that outside body, specifically says he didn't go as far as to attack me personally. So I'm not sure how you can reconcile those two things. You know, saying that Councillor Turner attacked people personally when the very person he's supposed to attack personally specifically says he wasn't attacked personally. I don't know where we go from there because it's just wrong. And anyway, then it comes on to the real kicker of that meeting, which was the World Drowning Day. This is the one where collectively a few people, and the ones that subsequently involved themselves in the investigation, collectively went into shock horror and said that what's been said is outrageous. Outrageous, I'm offended, I was upset, you know, all the other language that came. And some of the people who've been involved in this went as far as to start accusing Councillor Turner of being racist, using racist language. I don't get it. It's just not there, is it? You know, he didn't attack anyone personally. Attendees don't recall clearly what was said, but on a balance of probabilities, supported by the facts here, two statements did match. And that was that Councillor Turner said, it's not that they, South Asian or Afro-Caribbean communities, can't swim, but more that they don't want to. And he used the sort of, probably paraphrased it, you know, can't float, won't float sort of thing. That in itself is not a racist statement. And to imply otherwise is deeply offensive to Councillor Turner and to everybody else. You know, for clarity, Councillor Turner is not a racist. In fact, he supports minority groups a great deal, and he did on this specific occasion. He was the only one advocating an urgent need for those communities to learn to swim in greater numbers, because they die in greater numbers by drowning on the coast. There's nothing more unedifying than seeing a group of wholly white people playing the racial discrimination card to support their own ends rather than to support the people they claim to be protecting. The Black and South Asian communities require protection. They need to be encouraged to learn to swim. Their children and young people die disproportionately. The statistics are really alarming. You know, in America, 80% of Black people don't swim. Sorry, if that's new information, I beg your pardon. But in this case, Councillor Turner was very clear on this. There is absolutely no evidence to support racist comments made by Councillor Turner. So in conclusion, the investigation officer's statements in relation to these is disputed in the strongest possible terms. It's a crucial fact that, you know, the personal remarks are the ones that seem to be the ones that tip his behaviour over the edge in terms of whether it was acceptable at these meetings. I don't think there's any evidence to support that. I think there's a collection of statements made by people that can't recall exactly or clearly what happened. There's no supporting evidence for that. There's no recording of the meetings. There's no decent minutes to support it or anything from the minutes that support what these claims. They've been made later on in order to try and bolster the case. In fact, Councillor Turner's owed an apology for this, really. He should be congratulated for raising a difficult issue. Uncomfortable truths are never good to hear. People don't like it, but they need to be said sometimes. And it takes somebody like Councillor Turner, a councillor of great experience, to actually have the courage to do that. And I think it's a shame that after all the years that he did spend attending this committee, that nobody felt at any point to have a word with him or to instigate some mediation. Instead, he's been held out to dry for something that he didn't actually say. He made no racist comments whatsoever, and all he did was engage in decent debate. If anything we learn, you know, as a country, it is that, you know, if liberty is to mean anything or democracy is to mean anything, it's the right to say things that people don't necessarily want to hear. In this case, that's all Councillor Turner did. He frustrated people, he irritated people, but he didn't do anything to breach the member's code of conduct. There is no evidence in this investigation officer's report to suggest that. I conclude my summing up. Thank you.
Thank you very much, Mr. Taylor. Right, now I'll ask Mrs. Galone, the independent person, to provide her view on the matter.
Thank you, Chair. Yes, my views are on whether I consider there to have been a breach of the Code of Conduct. So I'm going back to page 19 in the bundle and the items 1 to 4. That's what I'll be considering. And I've read all of the papers and I've listened very carefully to what we've heard here today. I'm very mindful that we're talking about balance of probabilities, and therefore I've given some attention to the weight of the evidence we have in front of us, which are the statements from those at the meetings, the complaint itself, Councillor Turner's account of the events, the small comment in the chat, and the minutes of the meeting that have been available to the investigator as well. It seems to me that the events have taken place. Nobody really disagrees with that. It's the extent and the strength of feeling that's at dispute here, in my view. We've had representations that Councillor Turner is robust and passionate in his beliefs, and he puts that over, and that is understandable for a councillor. The question, I think, is how far those comments have gone. Have they gone too far? In my view, going to those 1 to 4 points on the breach of the code, I would say that items 1 and 2 have been breached based on the meetings, the behaviour at the meetings on the 5th of June and the 29th of June. On the 5th of June, there appears to have been a personal attack on the representative from the Environment Agency and the SIG themselves. And on the 29th of June, there was certainly a verbal attack on the RNLI representative who was treated, as the witnesses have attested, disrespectfully. And I think also it's important to take into account that we've heard that both of those meetings were disrupted quite significantly in achieving their purposes. So in that way, I do think that the code of conduct, which requires councillors to treat other councillors with respect, and representatives and partner organisations with respect, has been breached, in my view. I think that also leads to the fourth part of the issue we're considering, bringing TDC into disrepute. And I do think that that has done that by treating others with without respect. The third item, about failing to promote equalities and behaving in a discriminatory manner, I found more difficult to form a view on. I have looked at the headline of the code, which is saying that discrimination is about unfair treatment to particular groups. And I don't see that in the accounts we have of the meetings. I think those with protected characteristics haven't been subject to unfair treatment. But when you look at the LGA guidance notes, and indeed Mr. Kenyon draws attention to these in his conclusions on page 77, we also have to consider whether there were any comments, slurs, jokes, statements, questions or gestures that were derogatory or offensive to an individual or group's characteristics, and whether there were whether any of the comments promoted negative stereotypes relating to individuals or groups' characteristics. And I think the comments that were made could be seen in that particular light. I do believe that these are very sensitive matters, and as has been said, Councillor Turner hasn't been afraid to raise these matters. The language and perhaps the setting has been clumsy here, but I do think that it hasn't met the guidance about the code of conduct in that case. So those are my views on the breach of the code of conduct for the committee to consider.
Thank you very much, Mrs. Gillane.
Has the independent person got a view on capacity, which is also the issue?
It is. I wasn't aware that I needed to comment on that, but I have got a view, and I do think that Councillor Turner was acting with capacity for the reasons others have said, and his acceptance of that. Thank you.
Thank you very much. Right. I think now we're going to break for lunch, and while we break for lunch, we will deliberate. And our initial is that we have an hour, and I understand that officers have telephone numbers and they will get in touch to say, yes, we were going to reconvene in an amount of time.
Yes. I think the chairman's saying we will take telephone numbers
yes.
if you want to give us them, and then we can let you know at 1 hour's time how much further we're about to come back, or that we think there's going to be some more.
Yes, but we won't. It won't be sort of 5 minutes time, and you're sort of halfway down the road. So don't worry about that. But we will come back to you.
Well, thank you very much. I'm sorry it's taken us so long, and I know you've been waiting, which probably seems even longer. I do have the committee's decision here, which I shall now read. The case concerns a complaint received in August 2023 from Councillor Ernest Gibson of South Tyneside Council. Councillor Gibson was and is the chair of the Local Government Association's Coastal Special Interest Group, SIG, and presided at meetings of that group's meetings on the 5th and 23rd of June 2023. These meetings were held online. The complaint is set out in the investigator's report at page 37 of the report to this meeting as referenced at agenda item 7. In addition to the investigator's report on the behalf of this council's monitoring officer, the council received witness interview notes with the complainant, Sidonie Kenwood of the Marine Management Organisation, Becky McDonald Lofts as the lead officer for the SIG, Ross McLeod of the RNLI, Rhys Hobbs of Cornwall Council, Councillor Derek Basterman of North Yorkshire Council, who is also the Deputy Chair of the relevant SIG, Alicia Stockman of East Suffolk Council, Councillor Noel Gaylor of Great Yarmouth Borough Council, Nick Hardiman of the Environment Agency, and Councillor Nick Turner, the subject member of the complaint from this council. The committee also received 2 reports from the council's monitoring officer, referenced at agenda items 5 and 7 respectively. The report at agenda item 5 provided the committee with more generalised information around the complaint and the process to the meeting today. That report included the Code of Conduct, the Council's complaints procedure in respect to the Code, the hearing procedure and the Local Government Association's guidance on the Code of Conduct. The report at agenda item 7 included further detail of the specifics of the complaint and of items and advice and guidance. The defence submission from the subject member has been provided to the committee together with questions posed by him to Becky McDonald Lofts and her responses to those questions. Through today's hearing, the committee has also received oral evidence through statements made to it, responses to questions and the views of its independent person. The committee has considered all of these documents and oral evidence as part of its role in reviewing whether the subject member was acting in an official capacity to which the code applies and, if there was the case, whether there have been breaches of the code as described in the material presented to the committee. The facts. The crux of the complaint concerns interventions by the subject member at meetings of the Local Government Association Special Interest Group, SIG, on the 5th and the 23rd of June 2023. The SIG was attended by many representatives, councillors and officers from a range of coastal authorities who, like this council, were members of the SIG. The meetings were also attended by representatives of other agencies, authorities and national organisations with an interest in who contribute to the work of the SIG. Certain of the interventions from the subject member at the meetings were stated in the complaint and through the investigator's report to have breached the council code of conduct adopted by this council. The breaches of the code were stated as being of the general conduct paragraphs 1.1, 1.2, 2.3 and 5.1 of that code. At page 25 of the report to the committee in support of agenda item 5, the monitoring officer confirmed that the councillor's code of conduct of Tendring District Council had been adopted on the 22nd of November 2022 with a commencement date of 23rd of May 2023. On page 25 of the report of the monitoring officer at agenda item 5, the committee was informed that the subject member
had attended mandatory training on the Council's Code of Conduct on the 21st of June 2023. Prior to this complaint being considered now by the committee, there has been no complaint about the subject member and his language and behaviours at meetings of the SIG. The subject member has stated that at the meeting on the 5th of June 2023 of the SIG, he apologised and left the meeting. He also states that he apologised unreservedly in respect of his interventions complained of at the June 29th meeting of the SIG. Following the complaint being received, the subject member resigned from the SIG and subject member apologised unreservedly for any offence given upon the complaint being passed to him. The view of the independent person. The committee acknowledges the view provided to it of the independent person during this hearing. Decision of the committee. Based on the balance of probabilities of the evidence available, the committee concludes and decides that the subject member was acting in official capacity in his attendance at the meetings of the SIG on the 5th and 29th of June 2023. In reaching this conclusion, the committee is satisfied that it has received evidence of this council being a member of the SIG, the council paying the subscriptions required for the membership of the SIG, the sole member of the council in attendance at the meetings of the SIG being the subject member recognised membership of the SIG in his general interest form, the subject member making a claim for travel expenses on official business to attend a SIG event prior to the complained of meetings. There was a general acceptance of representation by all concerned at SIG meetings, and that in response to the complaint, the subject member resigned from the SIG. The committee then find, as a matter of fact, that the subject member's conduct amounted to a relevant breach of the Code of Conduct as follows. Code 1.1. I treat other councillors and members of the public with respect. At the 5th of June SIG meeting, we've put, here the breach amounted to behaviours to particular individuals in front of others attending the meeting and wholly disrupting the meeting as arranged. The interventions by the subject member took up a significant portion of the meeting time allocated for the meeting. This was being disrespectful to those other attendees. And for the 29th of June SIG meeting, here the breach amounted to behaviours to particular individuals in front of others. Here he failed generally to respect others who were in attendance. 1.2. I treat local authority employees and representatives of partner organisations and those volunteering for the local authority with respect and respect the role they play. At the 5th of June SIG meeting, here the breach amounted to attacks in a personal way on two of those who attended the meeting. The two individuals were Mr. Nick Hardiman, representing the Environment Agency, and Becky MacDonald-Lofts as the lead officer for the SIG. For the 29th of June SIG meeting, here the breach was the subject member's lack of respect by attacking a representative of an external organisation in a personal way. The representative here was Ross McLeod of the RNLI. 2.3. I promote equalities and do not discriminate. There is nothing against the 5th of June SIG meeting, but for the 29th of June SIG meeting, here the breach was the use by the subject. Oh, I'm really sorry, I'm going to have to read those again. 2.3. I promote equalities and I do not discriminate unlawfully against any person. There is nothing for the 5th of June SIG meeting, and for the 29th of June SIG meeting, here the breach was the use by the subject member of inappropriate language referencing a number of groups' characteristics that were taken to be offensive to those groups, and this was not promoting equalities. 5.1. I do not bring my role or local authority into disrepute. For the 5th of June SIG meeting, by acting as he did, as set out above, the subject member also brought this council into disrepute. It is noteworthy that there was evidence that certain representatives were considering leaving the SIG. And for the 29th of June SIG meeting, by acting as he did, as set out above, the subject member also brought this council into disrepute. Each separate finding of a breach of the Code of Conduct was then assessed against Article 10 of the European Convention on Human Rights to determine whether the breach, on the face of it, constituted an infringement of the subject member's rights under that article. The committee concluded that there was no such contravention of Article 10. However, the committee also considered that if there was a breach of Article 10 in any one of the breach areas, the consequential restriction on the subject member from the finding involved one which was justified by reason of the requirement of Article 10, subparagraph 2. The above constitutes the decision of the committee. However, the committee also would wish the following to be read into the record. It is noted that the subject member offered an apology at the meeting of the SIG upon receipt of the complaint and during the interview with the investigator appointed by the monitoring officer. The committee recognises the years of public service undertaken by the subject member on this council and in raising significant matters of public policy. Nothing in this hearing should seek to undermine that legacy. We do not consider that there was a conscious discriminatory intent by the words used at the meeting on the 29th of June of the SIG. We believe that the points being made by the subject member could have and should have been made in a different way, and that alternative language and behaviours could have made the points the subject member states he wanted to make, whether that was around policies to permit coastal retreat, the safety of sea users as a consequence of the closing of the RNLI boat stations, and the safety of different groups when going swimming in the sea. The committee does not consider any alleged failings by the SIG chairmanship secretariat should excuse breaches of this council's code of conduct for members. Yes. Now I'd like to ask the committee if there is a proposer and a seconder and whether we are all agreed in that afterwards. Is there a proposer for what I've just read? Thank you, Councillor Alexander. And Councillor Sarah Newton has seconded. And do we all agree with what I've just said?
Agreed.
Thank you very much.
Chairman, on page 7 of what was Part B report, there's a series of recommendations set out there. I believe that you have addressed certainly A, B, C, and C there, and on that basis won't seek to put those before you again. I'd like you to second and vote on that. And D is recommend any further consider any further recommendations arising from the hearing procedure. I think you might want to just revisit that. Yes. Probably a future meeting. Okay. When the views of all concerned can be taken. So, in my mind, I think that then dispenses with the recommendation. Therefore, you've concluded that.
Okay.
Yeah. So I think then just further on. Yeah. Sure.
All right. So 17. Okay. Sorry. Yeah. So on the basis that we have reached the decision we've reached, if the committee decides that the councillor has failed to comply with the code of conduct, it will then consider any representations from the investigator and or the
respondent councillor as to the appropriate sanction as set out in section 8 of the complaints procedure, and based on relevance to the breach being proportionate and necessary to promote and maintain high standards of conduct. Section 8 sets out the available sanctions as follows. 1. Publish its findings in respect to the members' conduct on the council's webpage. 2. Report its findings to council for information. 3. Recommend to the members' group leader, or in the case of ungrouped members, recommend to council or to committee that she be removed from any or all committees or subcommittees of the council. 4. Recommend to the leader of the council that the member be removed from the cabinet or removed from particular portfolio responsibilities. 5. Instruct the monitoring officer to arrange training for the member. 6. Recommend to the relevant group leader, or in the case of ungrouped members, recommend to council or to committee that the member be removed from all outside appointments to which she has been appointed or nominated by the authority. 7. Recommend to the relevant group leader, or in the case of ungrouped members, recommend to council or to committee the withdrawal of facilities provided to the member by the council, such as a computer, website and/or email and internet access. Or 8. Recommend to the relevant group leader, or in the case of ungrouped members, recommend to council or committee the exclusion of the member from the council's offices or other premises, with the exception of meeting rooms, as necessary for attending council, committee and subject committee meetings. Right. I recognise that Mr. Councillor Turner isn't currently a member of a political group on the council at the moment, and before I'll seek the independent person's view, I'd like to hear representations from the investigator and the subject member on those sanctions and the proportionate and necessary test I referred to. This step is set out on page 70 within the report, agenda item 5, the paragraph number is 6.3. Mr. Kenyon.
Yes, notwithstanding what the council's procedures say, my role is one of independent investigation, and I don't, as a matter of course, make any recommendations as to sanctions. I don't know the context. I don't know what's happened in the past, and I don't think it's appropriate for me to do it. So I won't make any submissions. Thank you.
Thank you very much, Mr. Kenyon. Mr. Taylor.
Thank you, Chairman. Well, quite naturally, we would prefer that the sanctions that we've already applied to Councillor Turner have already been quite sufficient. He's been without committee access for the last 6 to 8 months. He's lost his role in his party, had his party whip removed from him, and so on. I think that really, in view of the strength of the case against him, wasn't great. I appreciate that the committee's come to the decision that it has. I personally and Councillor Turner would obviously prefer that these aren't reported to council, or the findings are published, but we accept that what the committee decision is on that. However, any other things like the removal of him or the continued removal of him from outside bodies and from any involvement in committee, that's a loss to the people of Tendring. That's not a punishment, it's to Councillor Turner. And I would urge the committee to reconsider those actions. And likewise, if you remove his facilities to act as a councillor or to move around into the offices of the council, It's the citizens of Tendring that are going to be the loser on that, not Councillor Turner. So I'd ask you please not to consider those actions.
Thank you, Mr. Taylor. Mrs. Galoni, please, as the independent person.
Thank you. Yes, my view on the sanctions as set out in paragraph 17 of the agenda are that I do think it's necessary to publish findings and report the findings to Council in the interests of transparency and democracy. With regard to the Council appointments, I think the ongoing status of those is more a matter for the party and the Council rather than me to have a view on, so I don't have a particular view on that. In terms of training, I don't see the need for further standard training on the Code of Conduct. Councillor Turner has had plenty of training on that and has acknowledged that. But I do wonder if there's scope for perhaps some sort of one-to-one advisory session to reflect on this experience and how things might be done differently. But I'm applying experience elsewhere to that as a possible outcome. I don't know if that's possible within this council. And likewise on the outside appointments, I don't have a view on that. I think that's really for the council and the leader. The resource recommendations, sanctions numbers 7 and 8, I think that would be quite draconian to restrict access in that way. And although this is a serious finding, I don't think it's of the nature where that is necessary. So those are my views for the committee. Thank you.
Thank you very much, Mrs. Galoni. Right, we're going to go, the committee are going to go into the other room again, and we are going to come back with what sanctions there will be. Thank you, and hopefully we won't be too long.
Right, we've been away and we've come back with our decision as to the sanctions, and these are those. Oh, yes, thank you. Thank you for waiting. It's been a long day and hopefully it won't be too much longer, so I shall get on with these and then it'll be almost the end of the meeting. Right, the decision. The committee have considered the representations from the subject member and the views of the independent person. It also acknowledged that the investigating officer did not make representations on the sanctions. It is the committee's considered view that the following sanctions should be applied in response to the finding of the breach of the Code of Conduct for members, announced already. 1. Publish its findings in respect to the members' conduct on the council's website. 2. Report its findings to council for information. And 3. Instruct the monitoring officer to arrange training for the member. The suggestion from the independent person for this style of training to be more of a one-to-one reflective session around learning from the complaint is one the committee endorses. In addition, the committee finds that there should be an apology issued to the subject member to the Coastal SIG and to this council recognising the finding of this committee. Further, while recognising that decisions around the membership of committees for a non-aligned member, which the subject member currently is a matter for full council, the committee considers that any decision to appoint the subject member to a committee should be after the apologies requested have been issued and the training undertaken. Likewise, while the decision of the appointments to outside bodies is a matter for the leader of the council, the committee considers that any decision to appoint the subject member to an outside body should be after the apologies requested have been issued and the training undertaken. We hope the apologies and training can both be expedited and therefore not delay the appointments referenced. The committee considered that there was a breach of Article 10 in applying the sanctions concerned. However, and accepting that political debate has a higher protection under Article 10, the consequential restriction on the subject member from the sanctions applied are ones which are justified by reason of the requirement of Article 10, subparagraph 2. That completes the decision of the sanctions. I'd now like to ask for a proposer and a seconder for what I have just read, please, committee. Okay, Councillor Baker and Councillor Newton. Thank you very much. Is that agreed?
Yes.
You agree? Agreed. Thank you very much. Okay, now I just need to say that the decision notice will be issued within the next 7 working days following the hearing, and that the committee's findings will be published on the council's website and reported to the next full council meeting. And the meeting, the next standards committee will be held in here at 10 o'clock on the 10th of July. And that concludes the meeting. Thank you very much. And I'd like to say thank you very much to everyone for attending and all the time the officers have put in, and to the councillors and to everybody else, to the investigating officer and to the IPs. Thank you very much. And the subject member, I did.